is the registration of FIR is mandatory for the police. The word FIR stands for First Information Report. FIR is the very first information recorded by the police officer. The main objective of the FIR is to set the law in motion and also to enable the police officer to begin the investigation of the crime committed and collect all the piece of evidence. Now the important issue which arises for consideration is whether a police officer is bound to register an FIR upon receiving any information commission of a cognizable offence under section 154 of the Code of Criminal Procedure, or the police officer has power to conduct a preliminary inquiry in order to test the veracity of such information before registering the same. Section 154 of the Code of Criminal Procedure relates to the information in cognizable cases. As per subsection 1 of section 154 of the Code of Criminal Procedure, every information relating to the commission of a cognizable offence, if given orally to an officer in charge of a police station, shall be reduced to writing by him or under his direction and be read over to the informant. And every such information, whether given in writing or reduced to writing as aforesaid, shall be signed by the person giving it, and substance thereof shall be entered in a book to be kept by such officer in such form as the state government may prescribe in this behalf. Subsection 2 of this section says that a copy of the information as recorded under subsection 1 shall be given forthwith free of cost to the informant. The Code of Criminal Procedure describes about the cognizable offence and non-cognizable offence. Cognizable offence is defined under section 2 clause C of the Code of Criminal Procedure according to this. Cognizable offence means an offence for which, and cognizable case means a case in which a police officer may, in accordance with the first schedule or under any other law for the time being in force, arrest without warrant. It means in a cognizable offence, police may arrest without warrant. The first schedule as contained in the Code of Criminal Procedure for classification of the offences where bailable and non-bailable, cognizable and non-cognizable offence are mentioned. Section 156 of the Code of Criminal Procedure relates to the police officer's power to investigate a cognizable case. As per subsection 1 of section 156 of the Code of Criminal Procedure, any officer in charge of a police station may, without the order of a magistrate, investigate any cognizable case which a court having jurisdiction over the local area within the limit of such a station would have power to inquire into or try under the provision of Chapter 13. Chapter 13 of the Code of Criminal Procedure relates to the jurisdiction of criminal courts in inquiry and trials. Non-cognizable offence is defined under section 2 clause L of the Code of Criminal Procedure. According to this, non-cognizable offence means an offence for which, and non-cognizable case means a case in which a police officer has no authority to arrest without warrant. As per section 155 of the Code of Criminal Procedure, which relates to the information as to non-cognizable cases and investigation of such cases. As per subsection 1 of section 155 of the Code of Criminal Procedure, when information given to an officer in charge of a police station of the commission within the limit of such a station of a non-cognizable offence, he shall enter or cause to be entered the substance of the information in a book to be kept by such officer in such form as the state government may prescribe in this behalf, and refer the informant to the magistrate. Subsection 2 of this section says that no police officer shall investigate a non-cognizable case without the order of a magistrate having power to try such case or commit the case for trial. The ruling of the Honorable Supreme Court in the case Satvinder Kaur versus Government of NCT Delhi on 5th October 1999, the Honorable Court held that at the stage of the investigation, the material collected by the investigating officer cannot be judicially scrutinized for arriving at a conclusion that the police station officer or a particular police station would not have territorial jurisdiction. It is true that the territorial jurisdiction also described under subsection 1 of section 156 of the Code of Criminal Procedure. According to this, any officer in charge of a police station may, without order of a magistrate, investigate any cognizable case which a court having jurisdiction over the local area within the limit of such a station would have power to inquire into or try under the provision of Chapter 13. However, the subsection 2 of this section makes the position clear by providing that no proceeding of a police officer in any such case shall at any stage be called in question on the ground that the case was one which such officer was not empowered under this section to investigate. It means that if on the investigation it is found that the case at hand is not committed in a particular jurisdiction, the FIR can be transferred to the police station which has the jurisdiction of the area in which the crime was committed, and the police officer could not be called out for investigating a case which is later to be found not under his territorial jurisdiction. In another advisory of the Honorable Supreme Court, in case Ramesh Kumari versus Government of NCT Delhi on 21st February 2006, the Honorable Court held that a police officer is duty bound to register an FIR on the basis of such information disclosing a cognizable offence under section 154 of the Code of Criminal Procedure. A constitutional bench of the Honorable Supreme Court in a criminal writ petition number 68 of 2008 in case Lalita Kumari versus Government of Uttar Pradesh and others on 12th November 2013 had addressed the issue of mandatory registration of FIR and had held that the registration of FIR either on the basis of the information furnished by the informant when it makes out a cognizable offence under subsection 1 of section 154 of the Code of Criminal Procedure or otherwise under subsection 1 of section 157 of the Code of Criminal Procedure is obligatory. It is also held that the reliability, genuineness and credibility of the information are not the condition precedent for registering a case under section 154 of the Code of Criminal Procedure. It means the Honorable Supreme Court in case Lalita Kumari versus Government of Uttar Pradesh and others held that the registration of FIR is mandatory under section 154 of the Code of Criminal Procedure if the information disclosed the commission of a cognizable offence and no preliminary inquiry is permissible in such a situation. If the information received does not disclose a cognizable offence, what indicates the necessity for an inquiry, a preliminary inquiry may be conducted only to ascertain whether cognizable offence is disclosed or not. The Ministry of Home Affairs, Government of India issues advisory on 10th May 2013 and 5th February 2014 regarding compulsory registration of FIR under section 154 of the Code of Criminal Procedure. It means registration of zero FIR. It is clear that as per section 154 of the Code of Criminal Procedure, a police officer is duty bound to register a case on the basis of such information disclosing a cognizable offence. It is also clear that when it becomes apparent that even if the offence has been committed outside the jurisdiction of the police station, the zero FIR would still be registered and FIR would be then transferred to the appropriate police station as per section 170 of the Code of Criminal Procedure. In these advisories, it makes clear that a police officer is duty bound to register an FIR on the basis of the such information disclosing a cognizable offence under section 154 of the Code of Criminal Procedure. Legal position stated as expect that police shall register a case on the receipt of the information disclosing the commission of a cognizable offence under subsection 1 of section 154 of the Code of Criminal Procedure. Further, if after registration of the FIR, upon investigation, it is found that the subject matter relates to the jurisdiction of some other police station, the FIR may appropriately transfer to the police station in which the case falls. It means the FIR can be registered in any police station, and if after registration of the FIR, upon investigation, it is found that the subject matter relates to the jurisdiction of some other police station, the FIR may be transferred to the police station in which the case falls. This is the concept of zero FIR. The concept of the zero FIR is new. It refers to an FIR that is registered irrespective of the area where the offence is committed. The police may in such a case can no longer claim that they have no jurisdiction, and such a FIR then transferred to the police station that has the actual jurisdiction so that the investigation can begin. Justice Verma Committee established the concept of zero FIR. This committee was set up after the Nirbhaya gang rape case in Delhi to suggest the amendment in criminal law, and the advisory issued by the Ministry of Home Affairs is based on the committee recommendation. In view of the aforesaid discussion, we come to the conclusion that registration of FIR is mandatory under section 154 of the Code of Criminal Procedure if the information discloses the commission of a cognizable offence, and no preliminary inquiry is permissible in such a situation. If the information received does not disclose a cognizable offence, what indicate the necessity for an inquiry, a preliminary inquiry may be conducted only to ascertain whether cognizable offence is disclosed or not. If the inquiry discloses the commission of a cognizable offence, the FIR must be registered. In case where preliminary inquiry ends in closing the complaint, a copy of the entry of such closure must be supplied to the first informant within a week, and it must also disclose the reasons in brief for closing the complaint and not proceeding further. The police officer cannot avoid his duty for registering a case if cognizable offence discloses. Action must be taken against erring officers who do not register a FIR if the information received by him disclose a cognizable offence. The scope of the preliminary inquiry is not to verify the veracity or otherwise of the information received, but only to ascertain whether information reveals any cognizable offence. As to what type and in which cases the preliminary inquiry is to be conducted will depend on the fact and circumstances of each case. The categories of the cases in which preliminary inquiry is to be made are as matrimonial disputes, family disputes, commercial offences, medical negligence cases, corruption cases, cases where there is an abnormal delay in initiating the criminal prosecution, for example, over 3-month delay in reporting a matter without satisfactorily explaining the reason for delay. The Honorable Supreme Court also insisted that all preliminary inquiry should be completed within 7 days, and any delay with causes should be reflected in journal diary of the police station. In overall views, it makes clear that a police officer is bound to register a FIR on receiving any information disclosing a cognizable offense.